is a renowned and respected senior advocate, Mr. S Krishnan. On behalf of AK Law Chambers, I'd like to thank you for taking out time to educate the legal fraternity, sir. The floor is now yours, sir.
Thank you, Shiva. I should thank AK Law Chambers for this opportunity to share my thoughts on RERA. I would like to take you back to the 1950s for you to understand how real estate has developed and evolved to where it is today. Early in the 1950s and 60s, yes, there were companies, in fact, big companies, which were involved in forming layouts and selling individual plots to various persons. In fact, several of the layouts in Gopalapuram, Alwarpet, and then later in the 70s, areas like Adyar, Anna Nagar, they were all layouts which were developed, sold as plots. And then the individual owner used to put up constructions. Very rarely did we have a real estate company selling land and putting up construction also. Thereafter, in the 1970s, the concept of apartments or flats, as we used to call it then, became popular. Possibly it was a concept that we borrowed from Bombay. Primarily Bombay. Even Delhi had only individual, lands and individual houses, more of individual houses. And we had the concept of an apartment, the land being purchased by the promoter or the developer. The term used is promoter in the Act. And he used to develop or put up construction, put up the apartment, multi-storied buildings. Multi-storied buildings were very rare those days in Chennai. And the undivided share in the land were then sold to the various flat owners who wanted to purchase flats. This was the concept of undivided share was already there. In the sense you see an Hindu undivided family or co-parsonary or even co-ownership. Concept of undivided share was there only in areas, agricultural lands where 2 or 3 farmers could possibly hold members of the same family holding undivided shares in the same parcel of land. But the concept of undivided share of land being shared and owned by third parties, parties not known to each other, actually developed only in the 1970s when development of flats commenced. There were a lot of conceptually, they were not very thorough with the manner in which they should proceed. Actually, what happened was there were areas they used to buy, say, let us say 3 grounds in a particular place. That 3 grounds means 2,400 into 3 square feet of area. And the promoter never used to convey the entire undivided share in the land at the end of the project. In fact, this was one of the major problems faced by flat owners. After the completion of the flats, they realized that the builder still had some undivided share left with him for him to manipulate, and invariably they used to manipulate there could be a development by which the floor space index would be raised in the future by the competent authority, either the CMDA or corporation. So they will retain this undivided share so that they can construct further. And that apart, the promoters at that point of time really did not have the concept of other common areas like gyms, swimming pool, etc. Basically, it was just construction of, say, 10 flats in a particular site, undivided share given to the flat owners. If all the flats are of the same size, 1/10 share to each of the flat owners. At times, they will convey only 9/10 or 8/10, retaining 2/10 share with themselves for them to put up additional constructions as and when possible. Violations were rampant. The rules prescribed by the competent authority, the CMDA or the corporation, were violated in toto, whether it pertained to side setback, front setback, the height of the building, the height of each floor, and there was absolutely no mechanism by which these ills could be curbed. They had a field day, and in fact, in areas where they are not supposed to put up constructions. Then came the Town and Country Planning Act 1971, which replaced an earlier obsolete act which was passed in 1920. The Town and Country Planning Act essentially divided land area into several zones for development, classified it as industrial, residential, commercial, mixed, etc. I will not go into it in depth because it is not directly relevant. There used to be violations where again they used to put up residential constructions in area where only commercial constructions were permitted, and none of the rules were passed by the CMDA were followed, or any local authority were followed. So this became a major problem in terms of violation, and they were not in a position to really control. The remedy of an individual home buyer in those days was either to file a civil suit, or thereafter in 1986, after the Consumer Protection Act was introduced, go before the consumer forums, consumer courts for appropriate remedy. All of us are aware that the process of judicial disposal, both in the civil court and in the consumer courts, were very slow, delayed, and by the time the matter was over, it was nearly 10 to 12 years, by which time a home buyer whose only ambition was to have his own home would really suffer. The Consumer Protection Act initially was very effective. There were, because the power of arrest was granted under the Consumer Protection Act, but as cases piled up, it became an inefficacious remedy. People had to wait, and then the tiers of appeal, second appeals, etc., etc. It really didn't work at all. And so there were two remedies apart from an arbitration. And later in the 90s, all the developers, most of them at least, introduced an arbitration clause in the event of any dispute. This again was not an efficacious remedy, considering the fact that till 1996, it was the old Act 1940, which was replaced by the 1996 Act. Not that the 1996 Act helped either. So at the end of the day, after a great deal of deliberation, and the kinds of, earlier it used to be violation of the rules, violation of floor space index, etc. But at least they were getting delivery of the flats after a great deal of delay. Then we saw a new phase where the major players came in. I mean, earlier it was all small companies, partnership firms, and individuals who were actually involved in real estate. We saw the advent of very major players into the arena. They were all either multinational companies or very big companies, public limited companies, who catered to mass housing. And it was all multi-storied buildings, and when they entered again, the prices also shot up. The land prices shot up. It was what happened again was the remedy for the individual home buyer was always a dream. Then there was a development. See, from irregularities and violations, we reached a stage when many of the developers started cheating. They used to overbook. They used to enter into agreements of sale with the same flat with two persons. and they used to siphon money from one project to another, leaving the project from which amounts were siphoned at a standstill. So therefore, the need for a new enactment, for example, Consumer Protection Act was an enactment meant for a consumer in general, for goods, for services. So therefore, housing was only one of the services, or housing was only one of a service where you could approach the Consumer Protection Court. So they thought of, and another thing that really disturbed the lawmakers was the lack of transparency. A home buyer entering into a contract or agreement with a builder never knew what he was doing, what his financial status was, what was the sanction plan. In fact, I have personally in my career seen cases where there would be fabricated sanction plans. So you need to be really careful, and there is no methodology by which you could check up with the competent authority, and neither were they transparent. So therefore, it is the need for a new enactment which ultimately culminated in the passing of the Real Estate Regulation and Development Act 2016. Now, this act is a very comprehensive act in as much as it focuses on regulation of real estate, transparency in real estate, and clearly earmarking functions and duties of the promoters, allottees, as well as real estate agents. It's an act where if you go through the act, you will find normally you will have the sections pertaining to procedure and the sections pertaining to the substantive law would be bifurcated in any enactment. Here is a case where you will see in most of the sections, administrative functions and judicial functions all get mixed up. That will be if you see, it will all be jumbled up together. But nevertheless, in my opinion, I feel it covers every kind of a dispute that can be contemplated between a promoter, allottee, and a real estate agent. Now let us see how this enactment works. The first step, or in a real estate project, is the registration of the project with an authority called RERA, which has been established under the Act by the promoter. Section 3 deals with the registration process. Now let us see what are all the projects that you must also bear in mind another aspect. It is, for example, a particular promoter may have more than 10 to 20 projects under his wing. But each project requires to be registered. That apart, a project may be developed in several phases. If that is so, each phase has to be registered. And that is the purpose, so that people dealing with a particular project or a particular phase can know what exactly is the project, how many flats are to be constructed, how many floors are to be constructed, what is the sanction plan, etc., etc. Let us now see how Section 3 operates. Now, the Section 3, any project to be commenced by a promoter has to be registered. What is the effect of non-registration? Section 3(1) says that no promoter shall advertise, market, book, sell, or offer for sale, or invite persons to purchase in any manner any plot, apartment, or building, as the case may be, in any real estate project or part of it in any planning area without registering the real estate project with the Real Estate Regulatory Authority established under the Act. So therefore, a new project obviously comes within the net of Section 3(1). Now, what about a completed project. A project which has already been completed, for which a completion certificate has been issued by the competent authority, maybe the CMDA or the Corporation of Chennai or any other competent authority in any of the states. So once a project is complete, the registration is not mandatory, and therefore it is, with respect to any dispute pertaining to a completed project, you cannot invoke RERA. Though I should say that the appellate authority in Tamil Nadu had taken a view that even completed projects can be looked into, but I don't know whether it has culminated in an order. During the course of arguments, the bench expressed the view that they have powers to even go into a completed project or disputes pertaining to a completed project. The proviso to Section 3.1 says that projects that are ongoing on the date of commencement of this Act and for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this Act. So, ongoing projects, the projects that have not been completed in full, physically, and for which completion certificate has not been given by the competent authority. For all of you will know that in the Chennai metropolitan area, the CMDA gives a completion certificate, which means that they have inspected the project and assured themselves that the project is complete in all respects, and the completion certificate is thereafter given. Whereas in an ongoing project, in the Mofussil area, for example, the areas which come under, which fall outside the Chennai metropolitan area, which falls under the Director of Town and Country Planning, there is no mechanism like a completion certificate. So ultimately, they don't give you a certificate that the project is over. So therefore, what are all the ongoing projects? Ongoing projects, fortunately or unfortunately, has not been defined in the Act. They have not defined in the Act, and it comes into force from the date of commencement of this Act. So the Parliament, in its wisdom, left it open for each of the states to define ongoing projects in accordance with the rules and regulations pertaining to buildings in their state. Maybe that was a sensible thing to do. And the Act came into force. The Act came into force in two phases. Some of the provisions came into force in 2016. Section 3 came, along with other sections, came into force only in 2017, 1 year thereafter. The rules were framed thereafter. Now, I will take you to one controversial area as far as Tamil Nadu is concerned on the definition of an ongoing project. And this is also the cause for several disputes between the RERA, which is now currently on. Ongoing project, Section 2H of the rules, Rule 2H defines ongoing project as where development is going on and for which completion certificate has not been issued, but excludes such projects which fulfill any of the following criteria on the date of coming into force of subsection 1 of section 3. 1. In layout projects where land is developed into plots, the roads and open spaces gifted to the local body concerned. 2. This is the area of controversy. The projects in Chennai metropolitan area for which application for completion certificate has been filed with the Chennai Metropolitan Development Authority, subject to furnishing certificate from the architect, licensed surveyor, structural engineer associated with the project to the effect that all the buildings in the project have been structurally completed. That is, all columns, beams and slabs have been erected, supported with photographs. Look at this. Chennai metropolitan area clearly provides for a issue of a completion certificate. And obviously the application is pending for whatever reason. It is the fault of the CMD, or maybe the project is not complete in every respect. They say that in such cases, it is enough if the project is structurally complete in respect of the columns, beams and slabs alone. That is hardly 50% of the construction. So much more remains to be constructed. The ceilings, flooring, painting, electrical connections, etc., etc. Well, does it not smack of there's something in this which is really fishy? Obviously, the lobby of builders, well, I don't want to go into specifics. What they have done is they have more or less allowed incomplete superstructure to come within the definition of an ongoing project, or rather they say to exclude it from an ongoing project, and allowed them to go scot-free without registration. This is what has happened. So what happened is, and ultimately the CMDA or the Town and Country Planning Development Authority in respect of rural areas will publish a list of buildings which satisfy Rule 2H, 2 and 3. That means that thereby taking away a substantial part of the projects that are pending out of the purview of RERA. Subsequently, the RERA itself found out that many of these constructions were totally incomplete, and in a few cases, there was nothing at all on ground to show even construction has commenced. So therefore, the RERA and the Tamil Nadu Appellate Authority have held that they have powers to go into the veracity or the truth of whether a project has been completed by way of evidence in a complaint filed by an allottee, and that they simply will not reject an application just because it comes within the definition of an ongoing project under the rules framed, and consequently a publication has all the list of buildings that do not fall within the definition of ongoing projects have been published by both CMDA and the Director of Town and Country Planning. So therefore they said, no, this is something that we can look into. So we are not going to accept this particular rule. So now let us come back to the section 3.1. Now, what are all the buildings that have been, what are all the projects that don't require to be registered? So 3.2a says, where the area of land proposed to be developed does not exceed 500 square meters, or the number of apartments proposed to be developed does not exceed 8 inclusive of all phases. So therefore, they say that smaller projects than what has been actually defined in clause A of 3.2 is exempt. Such projects need not be registered. However, there is a proviso. Provided that if the appropriate government considers it necessary, it may reduce the threshold below 500 square meters or 8 apartments, as the case may be, inclusive of all phases for exemption from registration under this Act. Then B, of course I have dealt with it earlier, where the promoter has received completion certificate for a real estate project prior to commencement of this Act. C is very important. For the purpose of renovation or repair or redevelopment, which does not involve marketing, advertising, selling, or new allotment of any apartment, plot, or building, as the case may be under the real estate project. Now let us take an example of a residential complex or an apartment complex constructed in 1975. There are 100 owners, and they want to demolish this building and construct or reconstruct or put up a new building consisting of as many flats as permitted. Now, the intention there is not to market or sell like what a promoter does. So it is something which the owners themselves want to do for their own use. So such a construction, though you need to go and get the necessary sanctions for demolition and for putting up the residential complex, you don't have to get yourself registered under the RERA because it does not involve sale or marketing of the real estate project. So therefore, simpliciter, the long and short of section 3.1 is a promoter cannot commence his project without registration with RERA. Then, how is the section 4 deals with the application to be filed for registration. Now it gives the various kinds of documents, etc., plans, everything in detail, or whatever is expected, the sanction plan, layout plan. I won't waste my time on all those aspects, but there are two things which are important. If you see section 4(2) A to K deal with all other details and documents that are required for registration. L is a declaration supported by an affidavit which shall be signed by the promoter or any person authorized by him, stating that he has legal title. That is, then we go to capital C, that is 4(2)L capital C. The time period within which he undertakes to complete the project or phase thereof, as the case may be. And D, capital D, the next thing is that 70% of the amounts realized for the real estate project from the allottees from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of construction and the land cost, and shall be used only for that. A very, very important, strangely, it is not in the form of a substantive section. Normally, one would expect that there is a provision which says that the time period should be given and 70% of the amount received from the allottee should be deposited in a separate account which can be used only for purchase of land or for construction. Here, it is only in the form of a declaration in an affidavit filed by the promoter. Strange, but anyway, I think the contents of the affidavit are binding and he can be hauled up if he doesn't follow the rules specified in C and D. Now, then grant of registration, that is section 5. In section 5, on receipt of the application under subsection 4 of subsection 1 of section 4, the authority shall, within a period of 30 days, this 30 days is important, grant registration subject to the provisions of this Act and the rules and regulations made thereunder, and provide a registration number including a login ID and password to the applicant for accessing the website of the authority and to create his web page and to fill therein the details of the proposed project. So therefore, if all these details as stipulated in section 3 are given, the RERA, the authority, shall within 30 days grant registration, and on granting registration shall provide a registration number including a login ID and password to the promoter for him to put up all the details that are required to be put up by him under the Act and the rules framed thereunder. So therefore, if everything is fine and the details given by him at least are in accordance with the rules and regulations, RERA will grant him a registration. Or B, contemplates rejection. Reject the application for reasons to be recorded in writing if such application does not conform to the provisions of this Act or the rules or regulations made thereunder. So therefore, specifically they say if the application filed under 4 do not conform to the rules, the various rules and regulations framed under the Act and under the rules, the application ought to be rejected. And there is a proviso to this section which says that no application shall be rejected unless the applicant has been given an opportunity, personal hearing being given to him in the matter, so that he can clarify that yes, it has been met, or I will make a correction, or whatever it is, whichever way it is done. Subsection 2, according to me, is a little strange. So there can be only two options. One is grant or reject. There are other enactments where, now subsection 2, I will just first take you to subsection 2. If the authority fails to grant the registration or reject the application, as the case may be, as provided under subsection 1, the project shall be deemed to have been registered, and the authority shall, within a period of 7 days of the expiry of the said period of 30 days specified under subsection 1, provide a registration number and a login ID and password to this promoter for accessing the website of the authority and to create his web page and to fill therein the details of the proposed project. This really is a provision which is going to aid unscrupulous builders. I mean, if the scrutiny process of RERA is not over within 30 days, and for after the expiry of 30 days, within a period of 7 days, automatic deemed registration is granted, whether the application satisfies or conforms to the various rules and regulations. I mean, it gives an opportunity for a promoter. It beats me as to why there should be such a provision in an act like this, where normally what they do, such provisions are there in enactments. For example, an extension of a routine license under a particular act, it could be any act. Now, if the administrative authority, for various reasons, due to slackness, due to overwork, or expecting something else, will not do it. In such circumstances, in several enactments and rules, you will see a provision that there is an automatic extension granted if the authorities do not act within a particular period. But this is not one such. This is not a case where this should be done, because after all said and done, even if you put all the projects together in a particular city or a particular town, maximum they're going to be 200 or 300, and not that too, not at a time. Now this automatic registration can cause. Now what does it mean? Suppose the contents in the application are inadequate or contrary to the terms. I mean, does the promoter proceed with the project in accordance with what he has filed in the application, or should he conform to the rules and regulations? So possibly this particular subsection 5.2 requires a relook. Then comes extension. This is another section which is very interesting. Now there is a time period given by the promoter in his application. Let us say from the date on which the project commences, either by way of receipt of the sanction plans or whatever it is, I will complete the project within 3 years. Now he is expected to complete the project by virtue of the clause that I earlier read, that is 4.2 capital C. If he doesn't do it, what are the consequences? The registration granted under 5 may be extended by the authority on an application made by the promoter due to force majeure in such form and on payment of such fee as may be prescribed. This is the first part of section 6. Force majeure, there is an explanation for force majeure, which is, for the purpose of this section, the expression force majeure shall mean a case of war, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature. Caused by nature, we can also rope in the present problem that we are having, the present crisis that we are having owing to COVID-19. So, but where the difficulty comes is there is a proviso, second proviso to this section, provided that the authority, there's the first proviso I'm reading, provided that the authority may in reasonable circumstances, without default on the part of the promoter, based on the facts of each case, and for reasons to be recorded, in writing, extend the registration granted to a project for such time as it considers necessary, which shall in aggregate not exceed a period of 1 year. Now the issue is, the first part of the section speaks about force majeure conditions. The second, it is followed by a proviso which says that if the promoter is not responsible for any default or the delay and gives valid reasons for the delay, the RERA, the authority, can extend it for a period not exceeding 1 year for reasons to be given. Now, according to me, the way I look at this section is, there are two circumstances. One is delay caused on account of force majeure. The two is, though it is in the form of a proviso, an independent subsection which empowers RERA to grant an extension if the delay is for valid reasons and not due to the default committed by the promoter. I can think of two examples. There was 2 or 3 years ago, there was a crisis where when sand was not available at all. I think the High Court had passed an order saying that there should not be any the usual problem, sand mining. They were literally digging the river out, and there was an order. For a period of nearly 6 to 8 months, sand was not available at all. And even the import of sand took a long time. So according to me, the promoter is not responsible for this. Let us take cement or steel. Now, that is why actually it should not have been a proviso, but I should say the Supreme Court in Pioneer case, while dealing with the constitutional validity of the amendment that was brought to the IB court, wherein a home buyer was also included as a financial creditor, has dealt with RERA. They have merely extracted or summarized the entire act, and they have not looked into this at all. But nevertheless, it is there in the Supreme Court says that it is only force majeure. Even if it is force majeure, it is 1 year, not more than that. But I personally feel, mine can only be an opinion, I feel that it should be force majeure is independent, for which no time limit is given. If there is a delay on account of the on account of other reasons, not being default on the part of the promoter, extension can be granted subject to a maximum of 1 year. In any event, I think today the law is what the Supreme Court has stated in Pioneer's case. Then one other thing that has to be looked into here in the explanation is force majeure. They have clearly given 7 events of force majeure. So that you can't expand or you can't add anything more to it. The only clause where you can possibly add is calamity caused by nature. Then comes revocation. When can the registration be revoked? The authority may, on receipt of a complaint, or Section 7, the authority may, on receipt of a complaint or suo motu in this behalf, or on the recommendation of a competent authority, revoke the registration granted under Section 5 after being satisfied that the promoter has made default in doing anything required by or under this Act, or the rules or the regulations made thereunder. B. Promoter violates any of the terms and conditions of the approval given by the competent authority. Promoter is involved in any kind of unfair practice or irregularities. Unfair practice has also been in explanation given in detail, which I will not go into because there are several acts which have been construed to be unfair practice. So therefore, if an allottee can go before the RERA for revocation of registration, RERA, interestingly, at this point of time, carries out three different kinds of functions. One is advisory in nature to the government. It can give its view and opinion on several aspects pertaining to real estate for the government to take appropriate action. That is advisory or recommendatory in nature. Two, administrative. Now, the registration of an application by the promoter or the formulation of the rules or whether any other supervisory action is all administrative. The third function is quasi-judicial. So therefore, it is interesting. That is why the sections are also jumbled. And one part of the section will be procedural in nature, and then there will be one aspect of a substantive law, which one more example which you would see shortly. Now, what are the effects of revocation? Subsection 7(4) says, the authority upon the revocation of the registration shall debar the promoter from accessing its website in relation to that project and specify his name in the list of defaulters and display his photograph on its website, and also inform the other real estate regulatory authority in other states and union territories about such revocation or registration. So therefore, he is debarred from accessing its website and also he will be added in the list of defaulters, and his photograph will be displayed in the website. And they are also entitled to inform real estate regulatory authorities and other states if the promoter is a multi-state player. Now, it doesn't really help the allottees. Now, there is one other doubt that could crop up here. Now, this very same promoter may have 20 or 25 projects all over the country. Now, what they can do is only prohibit him from continuing with this project. He goes on happily with the other projects in other states or in other districts. So this is an area which possibly they have to, bring in legislation which will prevent such unscrupulous or irresponsible promoters from continuing with other projects. There is a vacuum here. Now, 4B is upon revocation, the duty of the RERA is this: shall facilitate the remaining development works to be carried out in accordance with the provisions of Section 8. So therefore, how do you alleviate the problems faced by the allottee on account of the revocation of registration of the promoter? Section 8, I will come to Section 8 shortly. So they'll have to take steps to continue the project with an alternative arrangement. And then another important power conferred to RERA on revocation is this: 4C, shall direct the bank holding the project bank account specified under subsection capital D of clause 1 of subsection 2 of 4. You remember that 70% that has to be deposited in an account. That to take such necessary actions to freeze the account and thereafter defreezing this said account towards facilitating the remaining development works in accordance with Section 8. So therefore, that power also, in effect, the money, if at all, that had been deposited can be frozen and can be used for the completion of the project, that particular project. Then Section 8. Obligation of authority consequent upon lapse of or revocation of registration. Upon lapse of the registration or on revocation of the registration under this Act, authority may consult the appropriate government to take such action as it may deem fit, including the carrying out of the remaining development works by the competent authority. Competent authority here is only a CMDA, but anyway, that's what the section says, or by the association of allottees, or in any other manner as may be determined by the authority. So they can bring in some other promoter who is ready and reputed. They can leave it to the association of persons, association of allottees to continue with the project in the manner in which they want to. So this is the remedy that is available for completion of the project after the builder exits. Then section 9 and 10 are registration of real estate agents. I mean, that's not really very important because I would like to cover because I already am running short of time. I will now go to section 11, which is functions and duties of promoter, which again is great detail. Each and every function is defined. I don't think it will be really formation of an association, etc., etc. I won't waste your time on that. But I would like to point out one particular subsection in section 11, which section 11 H is the provision which says, after he executes an agreement for sale for any apartment, plot or building as the case may be, not mortgage or create a charge on such apartment or plot or building as the case may be, and if any such mortgage or charge is made or created, then notwithstanding anything contained in any other law for the time being in force, it shall not affect the right and interest of the allottee who has taken or agreed to take such apartment, plot or building. Here, in the form of a non-obstante clause, they have brought in a provision which actually overrides provisions of the Transfer of Property Act. An agreement of sale normally does not convey title or transfer interest in an immovable property. It only confers an executory right for specific performance. Here, there can't be a mortgage, although there is, if you take the law as it stood before RERA, a mortgage could have been created. I mean, that agreement of sale would not prevent a promoter from mortgaging that apartment or the entire project itself. But here, they have made a very welcome change saying that if there is any mortgage of that particular apartment or flat, then it is not binding on the allottee. And therefore, the financial institutions also will have to be very careful while lending money. They should be very careful to ensure and see how many agreements of sale have been entered into prior to the mortgage. Then section 12, again, obligations of promoter regarding veracity of advertisement. I won't trouble you on that. And then again, adherence to sanctioned plans is section 14. Obligations of promoter in case of transfer of real estate to a third party. Obligations of promoter regarding insurance of real estate. And then, of course, transfer of title. Return of amount and compensation. Now, I will not go into all these details because it's all factual and most of it are many of which we know, which we can look into at appropriate time. Now, what is important is what are the rights and duties of allottees. Now, generally one gets the impression that this is an enactment which is meant only to benefit or for the aid of allottees. It is not so. In fact, this was a ground of challenge in the Bombay High Court when the constitutional validity was challenged before the Bombay High Court, and they said it treats to the promoter and the allottee differently, and the promoter does not have any remedy under the Act. It is not so. Actually speaking, if an allottee commits a default, Section 19 gives a remedy to the promoter to move the RERA for getting appropriate reliefs in the form of interest and also the principal amount or the due installments. So therefore, it is the RERA can be approached both by the promoter and the allottees. Section 20 is the establishment of the real estate regulatory authority. I will not go into the constitution, chairperson, etc., etc. I will go to section 31 straight away. 31 pertains to filing of complaints with the authority or the adjudicating officer. Now, there is another provision which enables an appointment of an adjudicating officer who will actually deal with the quantum. RERA does not look into each case and decide what the quantum of compensation or interest that a builder or an allottee is entitled to. There is a separate authority, the district judge appointed under section 79. Now, 31 says, any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be, for any violation or contravention of the provisions of this Act or the rules and regulations made thereunder against any promoter, allottee, or real estate agent, as the case may be. So the word used here is any aggrieved person. So it can be possibly a promoter, an allottee. And I would put one question. What about a landowner? There are the arrangements with the landowner could be of three kinds. One is he more or less gives the entire property for a particular sale consideration. Possibly the consideration is payable in installments and gives a power of attorney to the promoter. He gets the consideration only in the form of cash or money and not in the form of apartments in the proposed complex. Then it could be again, he could take his compensation or the sale consideration in the form of 50% in the form of apartments and 50% in the form of money. Now, in the case where a landowner himself, for example, the allotment of flats the promoter has not completed, even the landowner can approach in such a case. But that is why here the landowner has not been defined. But here they have said any aggrieved person. And automatically, I think that fills the gap, enabling the landowner also to approach RERA for appropriate relief if they are aggrieved. But if there is going to be any dispute pertaining to title, then I think they are out. They have to go only to a civil court. So there are instances where there are title disputes between the owner and other co-owners, which has to be sorted out only in a civil court. Then we'll go to the functions of RERA. Section 32, as I told you, there are three different areas of their functions can be divided into three areas. One is advisory and recommendatory to the government. Two is administrative, pertaining to the work, pertaining to supervising the promoter, the manner in which the entire project is going on, etc., etc. Three is judicial, which we just saw, 31. Now, 31 powers under section 35, they also have powers of investigation, 35. If they feel that a particular promoter or the action of a particular promoter or competent authority requires investigation, under 35 they can order so. Then 36 is the power to issue interim orders. In the form of an injunction or restraint order, they can do it, where during an inquiry, the authority is satisfied that an act in contravention of this act or the rules and regulations made thereunder has committed and continues to commit, that such act is about to be committed, the authority may by order restrain any promoter, allottee or real estate agent from carrying on such act until the conclusion of such inquiry, until further orders, without giving notice to such party. And then powers to issue directions is also there, and rectification of orders is also there. That is section 39. Section 40 is recovery of interest or penalty or compensation and enforcement of an order. I will read 41 and 42. If a promoter or an allottee or a real estate agent, as the case may be, fails to pay any interest or penalty or compensation imposed on him by the adjudicating officer or the regulatory authority or the appellate authority, as the case may be, under this act or the rules and regulations made thereunder, it shall be recoverable from such promoter or allottee or real estate agent in such manner as may be prescribed as an arrears of land revenue. So they have ultimately the RERA. Of course, you know, land revenue, an individual decree holder cannot invoke the procedure under the Revenue Recovery Act. So ultimately, it is the rules are silent about this. Actually, they should have covered this aspect also. But ultimately, the authority on an application made by an allottee who has an order in his favor should invoke and set the ball rolling under the Revenue Recovery Act. Then comes the Appellate Tribunal. I will state in the appellate, strangely, if you see, in contrast to Section 42, Section 57 says that every order made by the Appellate Tribunal under this Act shall be executable by the Appellate Tribunal as a decree of civil court, and for this purpose the Appellate Tribunal shall have all the powers of a civil court. There is an anomaly here. If an order of the RERA which goes on appeal to the Appellate Authority, the order is either modified or enhanced or reduced, that can be treated as a decree. But if the litigation stops with RERA, it has to be recovered by way of a land revenue. Anyway, that there appears to be an anomaly which possibly requires to be corrected. And then there is a second appeal to the High Court, where Section 100 of the Civil Procedure Court will apply. It can be only on substantial questions of law. Sections 59 to 69 are all sections which impose penalty on the promoter for various violations. The penalties are very stiff. It at times goes up to 10% of the value of the project or 5% of the value of the project. So it is definitely, these penal provisions will at least hopefully bring about order in the real estate sector. And the implementation of these penalties, in fact, in one section, if they fail to pay the penalty, imprisonment also has been provided for. So obviously, these penal provisions 59 to 65 cannot be retrospective at all. Anyway, there is one clear section which says that completed projects won't come within the purview of this Act. So therefore, these are all, then the power to compound is also there. Then 71, this is a very interesting section. Now, I won't trouble you with all the sections pertaining to penalty. They're totally about from 59 to 68. Power to adjudicate is where they have the power to adjudicate any dispute. Their district judge has been appointed as an adjudicating authority, and he will give finding. He will go into issues of quantum and grant you an order which will say that so much is due from either the promoter or from the allottee. Interestingly, there is one feature here, 71 proviso, provided that any person whose complaint in respect of matters covered under 12, 14, 18 and Section 19 is pending before the Consumer Dispute Redressal Forum or the Consumer Disputes Redressal Commission or the National Consumer Redressal Commission established under Section 9 of the Consumer Protection Act on or before the commencement of this Act, he may, with the permission of such forum or commission as the case may be, withdraw the complaint pending before it and file an application before the adjudicating officer under this Act. The Parliament in its wisdom realized that at least let us try to now give those allottees or home buyers who have been before the consumer courts for quite some time to file a fresh application before RERA, where they already filed a consumer complaint. So therefore, it recognizes that both the acts are not in derogation to each other. And that is what Section 88 says. 88 says, the provisions of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. In fact, in Pioneer case, the Supreme Court, after considering the provisions of RERA, IBC, and the Consumer Consumer Protection Act, have said that the allottee is entitled to invoke any one of the remedies available to him either under the Consumer Protection Act or under RERA. So they have concurrent jurisdiction, and the option is left to the parties who's invoking it. Then 89 says, Act to have overriding effect. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. And another interesting provision is bar of jurisdiction. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered by or under this Act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this Act. It is something similar to surface. So if there is some relief which is required by an allottee or a promoter and which falls outside the scope of the RERA, Real Estate Regulation Act, civil court jurisdiction is not barred. Whereas if it is going to be something like grant of compensation, or if you want to invoke the Act for punishing the promoter, you can come only under RERA. Now there is a very interesting interplay here between. I would like to put some questions to my friends. Now, civil court's jurisdiction is barred. What about arbitration? How do we go about it? Consumer court has got concurrent jurisdiction, and there is also a provision by which the matters can be closed in the consumer court and liberty given to him to move the RERA. But what about arbitration? Today, every construction contract or agreement with the promoter has an arbitration clause. Literally, if you say, can the promoter invoke Section 8 if a person moves RERA? This is going to be a very interesting question which is going to crop up repeatedly. Now, the very same issue was considered under the Consumer Protection Act. In fact, there are 5 judgments. I will just give the citation. Under the Consumer Protection Act, where the Supreme Court repeatedly says that a Section 8 is not maintainable. 1996 6 SCC 385. In fact, this is under the old Arbitration Act 1940 under Section 34 stay. 2005 SCC 294. 2012 2 SCC 506. 2018 11 SCC 337. 2019 12 SCC 751, which is the latest. Now, all these judgments say that the Consumer Protection Act is a special enactment, and therefore you cannot take away the right of a person who is entitled or for whose benefit the Act has been brought in. So therefore, we can possibly apply the same yardstick to the proceedings under RERA. In fact, there is one order of the Tamil Nadu Appellate Authority which says that Section 8 will not apply because this is a special enactment. So therefore, here a benefit is sought to be conferred on allottees and the promoters. And when there is a specific act with the tribunal, special tribunal constituted under the Act, you can only invoke the provisions of that particular Act and not go by way of arbitration. Looking at it practically, if RERA will become non-functional, if every promoter is allowed to invoke the arbitration clause. So therefore, this has also been considered. In fact, RERA has been considered in one judgment which was pronounced on 9/7 Amarapalli case, builder's case, a bench headed by Arun Mishra, where RERA has again been dealt with in detail. And then the interplay between IBC and RERA, where they say that the amendment to the Act which brings in a allottee or a home buyer into the net of a financial creditor was challenged. And the Supreme Court in Pioneer's case held that the amendment is valid and they in the apart from all the other constitutional provisions that they consider, they have specifically held that is where they said that the consumer court and they specifically say that if there is going to be a conflict between the powers of the code and RERA, the code will prevail. And ultimately, an allottee or a promoter goes into, if an action is initiated against a promoter by any financial creditor and resolution process commences, then the moratorium will apply even to RERA. So therefore, IBC will prevail, and in the liquidation process, the allottees are only entitled to what they are under the waterfall mechanism that is there under the IBC code. So therefore, the interesting factor is the interplay between these three acts. There are also some other judgments. Of course, Boozalan, which says that certain disputes are not arbitrable, where they also considered this particular aspect, saying that there is a special enactment, then you will have to go only under the special enactment. And any questions?
Yes, sir. There are questions. So we have a question from Honorable Justice P.T. Asha J.
Yes.
Sir, am I audible?
Yes, please go ahead. Please go ahead.
Yes, sir. So we have a question from Honorable Justice P.T. Asha J. The question is that even where buildings are demolished and renovated, if the purchases an undivided share, then is it exempt?
Is it breaking?
Is it exempted? Even where buildings are demolished and renovated, if the builder purchases an undivided share, then is it exempted?
No, see, the question is if there is going to be a development agreement as such with a new builder, whereby some of the existing owners exit the project and new persons come in, then it has to be registered. The whole purpose of that subsection is if there is going to be no marketing or sale to a third person pursuant to the project, then it will not apply. If suppose a builder says, let me give you an example. Now today there are about 10 flats in a particular apartment. Okay. The floor space index today permits, instead of 10 flats of the same size, 20 flats. And they enter into an agreement with a developer or a builder to demolish this and develop 20 flats instead of 10. The 10 out of the 20 will be given to the existing owners, but the other 10 will be sold to outsiders. So then you will come within the net of RERA. You have to register it.
All right, sir. Thank you. We have a question from Mr. Ram Kumar. Can an allottee file an application for registration of an incomplete project, or only the promoter of a project alone can register the project?
Can a party, you mean?
Can an allottee file?
No, there is no provision for an allottee. An allottee is an individual. Now, if suppose a project is incomplete, now that is where this problem of ongoing projects come in. If suppose a project is left midway and the promoter does not register it, the allottees can approach the RERA and ask for reliefs under Section 8, which also involves bringing in new builders or association of builders. An association of allottees can approach. They can.
All right, sir. Thank you. we have a follow-up question from Honorable Justice P.T. Asha J. If builder is given an undivided share as a consideration.
Come again?
If the builder is given an undivided share as a consideration, then can the same be exempted?
Obviously, the whole emphasis, see, why are you giving an undivided share to a builder? If you want to know, see, let me give an example. If these 10 flats are to be made 20 under the demolition and reconstruction, and no outsider is going to come into it, they can engage a contractor rather than a promoter. They can do it themselves. But the moment you convey an undivided share to a promoter, it means that it is meant only to sell it to a third party, an outsider. Then it becomes sale and marketing, and therefore registration is mandatory.
All right, sir. Thank you. We have
the whole purpose is, if you see, if I am going to put up an individual building, though the building will fall within the definition of a building under this Act, I don't need any permission or registration. The whole idea is to protect allottees, third-party buyers. So therefore, the example will be best answered by saying, if third parties are willing to come into the project by way of purchase, then registration is mandatory.
All right, sir. Thank you. We have a question from respected Senior Advocate Mr. K.G. Raghavan. What is the position if the application under Section 3 is not in order? Then deemed registration does not apply. What is your view?
Deemed registration will apply. That's a problem. See, if it is in order, registration is granted. If it is not in order, it is rejected. But if the RERA does not respond, then there is no question. See, we don't know whether it is in order, application is in order or not in order. So they get an automatic deemed registration on account of the inaction of RERA. And that was what actually I said it should be looked into, because you will be allowing a lot of mischief to happen if promoters who don't comply with the conditions file an application on an account of default of RERA, they get a registration.
All right, sir. Thank you. We have a question from Ms. Sushma. For an aggrieved purchaser, which is a better forum to proceed against the builder, Consumer Forum or RERA?
Definitely RERA, because things are happening there. One, it is a specialized forum, only such disputes are taken up. Unlike Consumer Forum, where there are several other disputes, purchase of goods, purchase of giving services, etc., etc. So it is one among the several services. Housing, medical cases are there, insurance cases are there. So there is no doubt at all that RERA is more effective, and it is functioning quite well as of now.
All right, sir. We have a question from Mr. Pranav. Who decides on whether the circumstances fall under force majeure? In the light of various judgments dealing with force majeure, where inconvenience is not impossible, how does the Act deal with it?
Yeah, ultimately the judge, whether a particular event would fall within the force majeure clause, will be either the RERA or the Appellate Authority. They have to decide.
All right, sir. Thank you.
After all, it's only unilateral act, is it? So if the RERA decides that it is force majeure, then they can grant an extension. According to me, there's no limit, but Supreme Court says differently. So it has to be only RERA, or you go on an appeal the Appellate Authority.
All right, sir. Thank you. We have a question from Subramanya Kaushik RS. Whether a suit for specific performance of the agreement of sale, within parentheses, or an alternative relief of fund against a builder/developer is barred by virtue of this Act.
Well, if you want specific performance, definitely it has to be only a civil suit. The RERA does not have the power. RERA is a creation of statute. So therefore, they have to function within the four walls of the sections which empower them to do a particular thing or not to do a particular thing. So if there is going to be a full suit for specific performance, it has to be only a civil court.
All right, sir. We have a question which reads as, is landowner also required to register under RERA in case of a joint development where if promoter and landowner is having 50% sharing ratio?
See, the promoter becomes, there is one provision which says that there could be a joint liability if the promoter also gets a share in the either in the profits or by way of, but the position is not very clear. But in a case where the promoter has no room to play, then I think his liability is subject to, I am not very convinced about it. For example, presently I am appearing in a case where the owner was supposed to be given 35% of the constructed area. The builder has defaulted. The allottees have gone to the RERA, saying that we have, of course, no allegations against the owner as such. But if you apply this logic, I have no control over the promoter at all. Money is collected by him using my power of attorney. And obviously, I can't construct, I can't get to the construction site. So we defended it, saying that, of course, then we were impleaded and we informed RERA that we also have a grievance. We are not filing a separate application because we may have to take appropriate action against the promoter in a civil court also. But we will cooperate. We cancel the power of attorney. And the RERA wanted to know whether we would renew the power of attorney. We said we can't do it. Nor can you compel us to do it. Because it's a case of default and my right to file a civil suit against the promoter also goes. But there is one other way of looking at it. By getting 35% of the apartments, they also become an allottee. Now, as an allottee, you can approach RERA. So that eventuality also is there. So if suppose I want monetary compensation from the builder and also completion of the construction, I can approach RERA for delivery of possession of the constructed area plus compensation for the delay and interest.
All right, sir. Thank you. We have a question from Mr. Naman Jabak. When the authority under the Act functions as a quasi-judicial authority, when an application under Section 8 of the Act, isn't the RERA authority bound to refer the matter to arbitration?
No. According to me, no. For these reasons, as I told you, it's a special enactment. And a forum has been created for allottees. And therefore, if you apply all the judgments that I have cited on the Consumer Protection Act is something similar. The Supreme Court has said it's a special law, and therefore it is Section 8 will not be applicable. Naman can look into those authorities that I have given. I have given all the authorities under that particular head.
Okay. All right, sir. The next question is from Mr. Avinash Wadhwani and Ms. Shruti Krishnan. In an incomplete project, comment before the Act was notified. If the RERA finds violation and cancels the registration consequently, the development agreement, what is the remedy available to the homeowners? This is relevant as the 70% consideration received from the developed flats was never retained in a separate bank account. Is Section 18 applicable?
Okay, the question is not very clear. Can you come again?
In an incomplete project, comments before the Act.
Okay.
If the RERA finds violation and cancels the registration and consequently the development agreement, what is the remedy available to the homeowners? This is the first question.
I think possibly Avinash was not there. The definition of ongoing projects. Now, ongoing project necessarily has to be registered. So once it is registered, the provisions of RERA will apply. So you can choose the remedy in accordance with what you want. So even for completion as well as compensation and interest. So ongoing project requires mandatory registration.
All right, sir. Next, the second limb of the question is, this is relevant as the 70% consideration.
One second, just a second.
Yes, sir.
Come again? Yes, tell me. Yeah.
Yes, sir. The second limb of their question is that this is relevant as the 70% consideration received from the developed flats was never retained in a separate bank account.
Was not
18 applicable.
Was not.
Was never retained.
70% was not retained. That's what he says, right?
Yes, yes, sir.
Yeah, you can. 18 will apply. You can. You can, because the remedy is pretty wide under RERA. Well, you can seek for recovery. See, the problem is, as in a civil case, on paper the remedy is there. If this gentleman has siphoned all the money, well, you get a paper decree and possibly you can get him imprisoned, invoking the penal provisions, or levy a penalty for the violation. There are about 8 violations listed. It will be one among them. Get a penalty levied, and if he doesn't pay, get him imprisoned. Practically, how you recover is a problem that Avinash very well knows in civil courts. If he doesn't have money, what do you do? In fact, there's one other way. I didn't have time. A clever or intelligent promoter can make use of the IB code itself, the IBC code, and go in for a resolution process through one of his friends or binamis or whatever it is, and it can be done. So therefore, today the system provides for people escaping, and it happens also in the NCLT. I'm sure. Genuine resolution process is one thing different. A resolution process just to wipe off certain debts and then still continue with your company through some other person is another.
All right, sir. Thank you. We have a question from Mr. Sashank Chaudhary, an advocate from Delhi. The RERA gives 5 years to a promoter to finish a project. But 2 years after the same, the promoter enters into an agreement to sell a flat in the said project to the allottee, wherein the agreement states that project will be completed in 5 years from the date of the agreement. Which period will prevail if the complaint filed before RERA?
If it is registered under RERA, only 5 years will apply. 5 years from the date of the date that he has given in his declaration. The agreement to that extent is null and void. Right? He can't enforce. In fact, there is also the rules. I'm not sure about the Delhi rules, but the Tamil Nadu rules are very, very incoherent and incomplete. They need to really spruce it up. But whatever period that is specified on RERA, it has to be finished within that period.
All right, sir. Thank you. We have a question from Mr. Jaysham Rao. Greetings, sir. As far as I have understood, Section 3 bars the application of RERA Act to the completed projects. However, another provision allows the complainant before the consumer forum to withdraw the complaint from the forum and file a complaint before RERA. What if the complaint before the forum pertains to a completed project?
A completed project, that's an anomaly. Actually, if there's nothing left, because RERA will not have any jurisdiction to deal with completed projects. So that's possibly a provision. If a project is incomplete, then possibly that's a good question.
Right, sir. We have a question from Mr. Hitesh Singhvi. How can an allottee know if the amount deposited in the scheduled bank has not been used to cover the cost of construction? There does not seem to be any corresponding provision entitling the allottee to have a right to verify the bank account transaction. What is your view?
Everything should be on the website. That is the provision. If you see the website details, every detail has to be given. The RERA can even direct the promoter to give any further details if you want. If you want to move RERA and say that this is what is happening. The whole idea is transparency. This enactment means whatever the builder is doing will be there. It should be there in the website. which has been allotted to them.
Okay, sir. We have a question from Advocate Mr. P.B. Balaji. A family develops a layout. Constructed portions are allotted to family members. Say the owners and the second generation, say their sons or daughters, who contribute for development. Will such a case require registration under RERA?
No, if there is... repeat the question, please.
A family develops a layout. Constructed portions are allotted to family members. The owners and the second generation, say their sons or daughters who contribute for the development. Such a case require registration under the RERA.
No, if it doesn't involve sale or marketing, it doesn't require registration. If it is going to be for the family and they pull in money and develop, it is not required. See, the whole idea is it is something like an agreement between 4 family members to develop their own property using their money. The idea, purpose of the act is that third parties who pay money would not be left high and dry by the promoter. If it is going to be a family affair for demolition, reconstruction, or whatever they want to do, then it requires no registration. See, in all the earlier sections, you will find that it is a sale. 1 second. I'll also read out that the definition of. So, and if that sale aspect is not there, then you see even the real estate agent definition it will be there. 1 second. See, you read the definition of promoter, it will very clearly say it's all for the purpose of sale. For the purpose of selling all or some of the apartments or plots. A person who develops a land into a project, promoter, there are about a person who develops land into a project, whether or not the person also constructs structures on any of the plots, for the purpose of selling to other persons, all or some of the plots. So even if you sell a few of the plots, it requires registration. But otherwise, it does not.
All right, sir. Thank you. We have a question from Advocate Mr. Mukund. Is a landowner who had given a power of attorney to a developer is a necessary party to RERA proceedings? Is he liable? Is he also liable to the allottee who sued the developer?
He will not be liable because he has given a power of attorney. He will not be liable. He can always be impleaded as a party. There is no prohibition. But at the end of the day, he can't be made liable. In fact, there is one provision. The definition of promoter, any other person who acts himself as a builder, that is promoter Z2 ZK subsection 5, Roman 5. Any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name, or claims to be acting as the holder of a power of attorney from the owner of the land on which the building or apartment is constructed or plot is developed for sale. So there again, the onus is only on the developer.
All right, sir. Thank you. We have a question from Advocate Akila Sengotavan. Explanation to Section 31 defines person. Landowner does not come under the purview as per their explanation. Also, does Section 2ZK include landowners? If so, would the landowner be still an aggrieved person?
A landowner can be an aggrieved person, definitely. But a landowner will not necessarily be liable for the acts of the promoter. There is a very big distinction there. Now, as I pointed out in my example, say there are about 30 out of the 30% of the constructed area is to be given to the land owner. He becomes an allottee automatically. But suppose it is only a money, the sale consideration is paid by the developer by way of cash alone or by monetary consideration. Then my remedy is elsewhere. So according to me, the landowner really cannot be made liable if the transaction between him and the promoter is one of sale of the property, absolutely.
All right, sir. Thank you. We have a question from Mr. V.S. Jayakumar, Advocate. If there is a conflict between the Transfer of Property Act and RERA, should it be raised before the RERA or civil court or a writ court?
No, there is no conflict except that one portion which I pointed out, where the proviso says after an agreement is entered into between the promoter and the allottee, any mortgage made by the promoter in favor of a financial institution can be ignored by that is the only conflict, and that's a non-withstanding clause which has been given. Otherwise, there is no direct conflict with Transfer of Property Act.
Okay, sir. Thank you. We have a question from Advocate Mr. Sudhakar. Since you have suggested that landowner can come under definition of an aggrieved person and sue the builder within brackets as promoter for the delay in completion or default, will the builder come under the definition of an aggrieved person and sue the landowner / promoter if his title to the property becomes bad because of the subsequent acts?
If his title, who's the landowner's act? Can you repeat the question?
Yes, sir. Since you have suggested that the landowner can come under the definition
as an allottee, yeah, correct.
As an aggrieved person, sir, not as an allottee, and sue the builder as a promoter for the delay in completion or default, will the builder come under the definition of an aggrieved person and sue the landowner / promoter if this title to the property becomes bad because of subsequent acts?
Very interesting. Yes, prima facie he can. It's an interesting question because normally such things also happen. It is not as the default on the part of the promoter is normally very, very high. But it looks like it can be done. But actually, apart from the word any aggrieved person, there is no other provision which specifically gives them the right. But you can possibly say because the landowner is also part of the project. I mean, in the sense you see, he is the person who is giving the land. So therefore, this interpretation is very much possible. Though I have not seen any such case being filed so far, to the best of my knowledge.
All right, sir. Thank you. We have a question from Mr. Praveen Setia. When a promoter does not complete the project and hands over the flat to the allottee as per the time stipulated in the agreement, which is the best remedy for an allottee to enforce his rights? Okay, sir. Yeah. Thank you, sir. We have a question from Ms. Niveda. Sir, can the right of a home buyer before RERA and Consumer Forum coexist? For example, the home buyer is free to file before RERA for possession and before Consumer Forum for deficiency of service.
If the relief claim is the same, see, for example, what is it that an allottee can claim for? It's a question of ultimately compensation, interest, and delivery of possession. If you ask for it here, you can't ride on 2 horses, general law. So you can't ask for it amounts to forum shopping. That is why the Act provides for abandoning your case before the consumer courts and then coming here.
All right, sir.
That will apply only to projects which commence after 2016.
All right, sir.
Yeah.
All right, sir. Thank you. We have a question from Ms. Revati. If a part of the project only is registered under RERA, then what happens to the service agreements, wherein the service agreements for a prolonged period with the allottees proper to RERA and the subsequent allottees, wherein RERA specifically mentions that amenities which are common to all phases are to be handed over to the association?
Can you repeat it again? Question.
If a part of the project is registered under RERA then what happens to the service agreements where such service agreements for a prolonged period with the allottees, which are proper to RERA and the subsequent allottees? Now, wherein the RERA specifically mentions that amenities which are common to all phases are to be handed over to the association.
See, there are two things. Okay, now let us take a huge project where there are 5 towers or 6 towers. Now, first phase is the first tower. Now, the common amenities for the first tower, say water, or any other common amenity that you can think of, will be part of the sanctioned plan of that particular tower. Now, they are entitled to that. But at the end of the day, there could be, after all the towers are raised and the entire project is completed, there can be a gym, there can be a swimming pool, children's play area, a small school, library for the entire 5 towers. So therefore, you will have to see what are the exclusive common rights for that particular tower, which you are entitled to enforce. No doubt at all. That is how you will have to look at it.
All right, sir. This will be the last question that we are asking. And due to paucity of time, we shall not be entertaining any more questions. And our sincere apologies to not entertain any more questions. But this question is from Mr. C. Suraj. Is an order passed by adjudication officer directing the builder to return the amount to the allottee under Section 18 of RERA be treated as a decree? If so, can the allottee having obtained an order/decree from RERA be considered as a financial creditor to file an application to initiate CIRP as against the builder under Section 7 of the IBC?
Repeat, please. Order passed by the
adjudication officer directing the builder to return the amount to the allottee under Section 18 of the RERA be treated as a decree.
Yes.
That's the first limb of the question, sir. Second limb of the question is that, if so, can the allottee having obtained an order/decree from RERA can be considered as a financial creditor to file an application to initiate CIRP against the builder under Section 7 of the IBC?
Yes, it can be done. Because he is a financial creditor. Being an allottee, a home buyer itself, he becomes a financial creditor. Today, he has an additional order in his favor, directing the builder to pay certain amounts. Definitely, he can file an application before the NCLT.
All right, sir. Thank you so much for enlightening us on this area of law today. Once again, on behalf of AK Law Chambers, I would like to extend our sincere gratitude to you for having taken time out to educate the legal fraternity, especially youngsters who are new to the profession and students of law.
I thank Anirudh and his team and 2 of his juniors, Advait and Ram, who have really helped me in preparing for this seminar. Thank you, Shiva. And I thank all my friends who have been patient enough to listen to me for such a long time. Thank you.
Thank you so much, sir.